Good afternoon and welcome to another episode of Legal Tuesdays. I'm Monica Miller and I answer your questions about separation of church and state. The question I will take today is from a teacher. I will keep the teacher anonymous for now, who says that their superintendent has repeatedly proselytized religion using his school email address to the entire district staff. This has occurred for many years. The content of the emails include, "I have prayed for you," "God brought me to blah, blah, blah," the name of the school. And it also, he also frequently quotes Bible verses and other sermons. The teacher asks whether this is constitutional. The answer, like many I give on this series, is that it depends. There's a lot of variables at play. What we primarily want to look at three things. One is, who is the speaker? Is it more likely to be ruled that it was a private person speaking in their private capacity, or is it the government speaking? Secondly, we look at the audience. This is limited to teachers, not students. That doesn't make it constitutional, but it's just a variable. And third, we look at the content of the emails themselves. Is it someone just saying "God bless" at the end of each email, which is annoying, but probably not something we would get involved with? Or is it frequent proselytization? In fact, the frequency is actually really a fourth variable. Is, if every day it's "I'm praying for you" and, "God has brought me here" and this and that, even though those might be a little bit more generic than, say, a sermon, the frequency of it matters too. So, and then a fifth variable that we look at that's not really relating to whether this, it does relate to whether this violates the Establishment Clause, and that's the jurisdiction. There's plenty of jurisdictions, unfortunately, in our country that are heavily stacked with judges that are not in favor of separation of church and state, and many of them have been appointed by former President Trump. Unfortunately, in those jurisdictions, even if we have something that we would consider very strongly an Establishment Clause violation, according to precedent by the Supreme Court, for decades, it still would not necessarily be an Establishment Clause in one of these jurisdictions. So we do need to look at that, especially in today's world, unfortunately. So with the facts of this scenario, which is a superintendent using his school email address, so that he's using the machinery of the state to email a captive audience of faculty. There's even though they're not students, they're not as impressionable, they're still they're still they're sort of supervisees to a supervisor. So there is an imbalance of power, and the boss is sending them emails about religion and God and sermonizing and providing Bible quotes. So I would say this absolutely rises to the level of an Establishment Clause violation, and is probably something we would send a letter on, regardless of jurisdiction. The nature and extent of the violation would probably determine whether or not we would bring it to court, as well as whether or not it could get resolved by a letter. I hope that answers your question, and I look forward to talking to you in the next segment of Legal Tuesdays.